Hi, I'm Rob Carolina. This is one part of a multi-part introduction to the law and regulation knowledge area of CyBOK. The law and regulation knowledge area is one of 19 knowledge areas in the entire project. The webinar that introduces this knowledge area is pretty long, and so I decided to break it up into 15 constituent parts. You are now about to listen to one of those parts. If you haven't already done so, I would recommend that you go back and listen to the introduction. It's also labeled Part 0. That'll help you understand what's about to happen. Alternatively, you can listen to the entire webinar as a single file. So without further ado, let's listen to this part. That leads us into data protection. Data protection is a series of legal restrictions on the collection, disclosure, and use of personal data. In the world today, European Union law, specifically GDPR, is the most influential example of data protection law. It's not the only one. Many countries around the world, many states around the world have laws that are either described as data protection laws or operate in a very similar fashion. Australia, New Zealand, Israel, Japan, China, all these jurisdictions have some type of data protection law. But the European Union's is the most influential. Data protection is more than just a law about privacy. It's kind of grown up out of privacy laws over the decades, but data protection law is an attempt to provide some measure of control to living data subjects about how their personal data is used. It's my opinion, for various reasons, that data protection law is really a reaction to the birth and growth of the modern administrative nation-state and the modern enterprise. If you're talking about data protection, you might as well use the specific terms of art that describe the key players in the data protection regulation game. Data subject, data controller, data processor. The data subject, of course, is the natural person to whom personal data relates. A data controller is the person who controls the dissemination of personal data. Dissemination or other processing, let's say. The data processor, on the other hand, is a person who's merely processing personal data under the instruction of a data controller. When data protection law first started many decades ago, lawmakers thought that they were regulating people who ran computer systems. So a lot of regulatory focus was on what we now call the data processor. Let's figure out where computers are. Let's get a list of them, get a list of people who run computer systems and find out what that's about. Well, as computers became ubiquitous, as everyone began to have a computer or tens or thousands or hundreds of thousands of computers under their control, the regulation shifted focus. And people realized, no, really the person we want to focus on is the data controller. After all, they're the ones making substantive decisions about how data will be processed. The focus shifted significantly in the direction of the data controller. Now, more recently in GDPR, regulatory focus has come back out again to the data processor because what people have realized is that in the modern age, a lot of data processors are people offering cloud-based services, especially software as a service. And in that kind of service architecture, the data controller might be buying the service, but they're not necessarily specifying how the service is going to operate. The data processor is doing that. So in GDPR, there's now, once again, a much more balanced approach to obligations between these two parties. What is actually regulated? Okay, if you're going to figure out whether or not data protection law applies to a particular problem, then you need to know whether or not you're processing personal data. So here we have the definition from GDPR on what's meant by processing, and as you read the language here, I think you will agree that this constitutes almost anything you could possibly imagine doing to data. Collecting it, recording it, disclosing it, analyzing it, deleting it, erasing it, destroying it, all these things that you might or might not do with data all constitute the act of processing. The question naturally becomes, are we processing personal data? All right. So personal data is data concerning a living individual. Personal data includes data capable of being attributed to a living individual by any person, even if that person is unknown to you, even if it's somebody else. In practice, this means that pseudonymous data, encrypted data, any data capable of de-anonymization by anybody, anywhere, is personal data. It's not enough to say, but I can't. If you're trying to figure out, are you a data controller, controlling, or a data processor, processing personal data, and you look at the data set and you say, well, I don't see any personal information in there. That's not the test. The test is whether or not there is anybody out there in the world who is capable of attributing this data to a living person. This leads to what I think is one of the biggest areas of confusion that I've seen in cybersecurity over the past decade. And that is the slow erosion of the use of the word personal data, phrase personal data, replacing it with PII, or personally identifiable information. So I've drawn a kind of a Venn diagram to try to tease out this distinction, and I've written about this extensively in CyBOK because it is such a source of common confusion. If we look at the definition of personal data in the law of the European Union and other places, and then we compare it with the definitions of personally identifiable information, PII, found in technical standards, ISO 29100 or NIST 800-122, I think if you read those definitions, it's kind of difficult to see how terribly different they are necessarily. Certainly the ISO and NIST definitions embrace the idea that something remains PII even if you can't tell the identity of the person involved. And so these relationships in this particular Venn diagram are a bit, let's say, imprecise. It's not entirely clear how they overlap. However, we then get to a very big problem. And that is the phrase personally identifiable information has been used in the statutory language of a number of laws in the United States. Going back at least as far as the late 1980s, a very famous law that specifically regulated what you could do or could not do with the records of video rental records. This was, of course, back in the day when you would walk into a shop and ask for a VHS tape, and the rental company would keep a record of what you had rented. And there were some questionable practices by some folks at that time, and so a law was passed. And the phrase that they use in that law is personally identifiable information. That phrase kind of stuck, and so it began to be used in a lot of other U.S. laws. But the definition that's been adopted by the U.S. Congress in a number of different laws is not necessarily the same as the definition given in the technical standards above. So we've seen, for example, some cases brought against folks like Netflix trying to apply this old 1980s law about video rental records to data that's being collected by Netflix, and the court trying to figure out what does or doesn't apply. Now, in those circumstances, we've had U.S. courts who've decided that personally identifiable information means kind of what it sounds like, and that is if I can identify someone by just looking at the data, that makes it PII. And if I can't identify someone just by looking at the data, then it's not PII. Now, bear in mind, those are definitions of U.S. laws by U.S. courts, and their purpose in interpreting those laws is to try to figure out what did Congress intend to do. That has nothing whatsoever to do with the technical standards. That has nothing whatsoever to do with the definition of personal data. So this causes a lot of confusion when you have cybersecurity practitioners, especially those who are familiar with the U.S. system or who are working with U.S. companies, who get to this question of, do we have PII in our system? Well, for legal purposes, that might not in any way be important if you're worried about data protection law. This isn't the end of the problem, though. There's a much smaller universe of PII that I describe as the definition that we all talk ourselves into believing because we end up in multiple committee meetings at an organization where somebody in the organization invariably says, well, do we have a compliance issue here? Well, only if there's personal data. All right. Then somebody says, well, do we have PII? That's mistake number one, because you're now asking the wrong question. And now that we start talking about PII, people go all around the table and they say, well, I don't know. Can you identify anybody from this data set? Do you know? Well, I'm not sure if that's it. Well, I can't identify anybody. And eventually everyone just kind of tries to persuade themselves that, no, we're not going to have to do a compliance analysis here because we've just persuaded ourselves that this is PII. Now, in the text of CyBOK, I've spent just a very brief amount of time talking about the core data protection principles, things like fair and lawful use of personal data, the retention principle, and I haven't spent too much time on it because there are a lot of good quality resources available for practitioners, and I've cited to a few of them that I think are good. They've been published, for example, by the European Union itself, and many others that have been written that are worth looking at. I have highlighted briefly that if you're involved in the investigation and prevention of crime, there are some additional things that you want to look at. Now, obviously, if you're working for a state, if you're in the police service, then there's a different body or related body of law you have to look at, not GDPR. You would then be looking at the directive that was adopted at the same time. But I then spend a bit more time talking about the concept of appropriate security measures and the assessment and design of processing systems, because these are the kinds of subjects that I find security practitioners get involved in much more deeply. If you want to become a data protection compliance person, just know that there's a lot more that you need to address that goes beyond security measures. Similarly, international data transfer comes up quite a bit, and it's often a source of confusion. So I've spent some time talking about the adequacy decision mechanism used by the European Union, and also data breach notification. Now, in this context, I've made some references to the law of U.S. states, who were some of the first people in with data breach notification rules, and I've then talked in detail about the rules that were adopted under GDPR and that became effective in 2018. Finally, I mention enforcement penalties. This has really, more than anything else, triggered a lot of focus on data protection. The number one thing that has elevated data protection to a sort of, let's say, a tier 1 risk that organizations want to think about are not substantive changes to the rules, but changes to the penalty involved. And as you can see, there have been some really eye-wateringly large fines proposed for violating GDPR.